morning, everybody, and welcome to our training for today. It is 5 minutes past 9, so we are going to get started. So just a little bit of an introduction to myself. My name is Danelle Gopal. I am an HR consultant here at HR Talk. All right. So today we're going to dive into managing misconduct, poor performance, and incapacity in the workplace. So just in order to ensure that we have smooth connectivity throughout our webinar today, I am going to switch my camera off, but I'm sure that you all can see the slides and hear me quite clearly. All right. So before we go into managing misconduct, incapacity, and poor performance, these are all types of discipline that we first need to understand. All right. And in order to understand discipline, we need to know what it is and what is the purpose that it serves. Okay. So the dictionary defines discipline as the practice of training people to obey rules or a code of behavior. All right. And when we look at the purpose of discipline in the workplace, we need to understand why we're using it. What is the purpose of it? Okay. What is it supposed to do? Why do we issue warnings? Why do we have policy? Okay. The purpose of discipline is very simple. What we're trying to do is correct behavior. Okay? Somebody said that we need to. Sorry. I'm not sure. I think there's a comment that the mics are muted and you guys can't hear me. Can we just get a thumbs up or something that everybody can hear me? Thank you so much. All right, perfect. So like I was saying, we need to first understand the purpose of discipline before we can dive into the different types of discipline and how we go about in terms of processes and addressing these issues in the workplace. So the main purpose of discipline is quite simple. It is to correct behavior. All right. That is the goal. That is the aim. We are not there to terminate or dismiss individuals. What we want to do is create a harmonious, cohesive, positive working environment. And in order to do that, we need everybody to obey the rules or code of behavior. So when someone doesn't do something that they're supposed to do, so they break a rule or they do not obey the standard of behavior that is required, our first instinct should be, how do we correct this behavior? How do we change the behavior that this employee is showing us? All right. The easiest way to understand it is by me giving you an example. Okay, so for those of you who have kids or have been around kids, all right? So when, let's just say, for example, you have a scenario where you have a kid, whether you're babysitting, whether you're watching a kid, whether it's your kid, I'm not sure, but let's just say you have the stove on, right? And the child goes in to touch the stove. Okay, the stove is hot and the child goes to touch the stove. Your first instinct, or the first time the child goes there, what do? You say, no, do not touch that. It is quite hot, and you explain what can happen. So you explain the consequences. You say, if you touch it, you're going to get burnt, you're going to get hurt. Okay, so do not touch the stove, right? The child ignores you, and then they go again and they go to touch the stove. What do? Okay, you might say, no, you need to stop. Okay, you get a little bit more aggressive in terms of the way you speak. Maybe you yell, maybe you shout, maybe that's what you say. All right. And now the child still doesn't listen, okay? And 10 minutes later, they go back to touch the hot stove, okay? Then what do? You get a little bit more aggressive in the way that you handle the situation. You might give the kid a timeout. You might take away their favorite toy because they're refusing to follow an instruction or refusing to behave the way you want them to behave in. All right, that is discipline. Okay, you are trying to get the child to correct the behavior that they are currently portraying. What do you want them to do? You want them to not touch the stove. Why? Because it will have negative consequences. All right, so at this point in time, you've tried the first, you've tried the second, you've tried the third, okay? In all three instances, you are trying to get the child not to touch the stove because there are negative consequences. You are trying to correct the behavior that they are portraying. In essence, that is what discipline is. We are trying to correct the behavior that is portrayed by employees in order for them to either obey the rules or abide by a standard code of behavior. All right? So when we look at the different types of dismissals in the workplace, there are, in essence, four types of dismissals, all right? So the first is misconduct, okay? So this is an act or omission to act by an employee, all right? The employee has broken a rule or code of behavior or standard code of behavior. This implies that the employee is at fault, okay? It is in essence, a will not. They know the rule, they know what needs to happen, they are aware of the standard or the code of behavior, but they are choosing not to follow this code of behavior. They are choosing not to obey the rule, all right? So this implies they are at fault. That is misconduct. Okay, the second type of dismissals that we have is dismissals for incapacity. Now, incapacity is a little bit different compared to misconduct. Incapacity is when the employee is temporarily unable to work, so they are incapacitated on the grounds of ill health or injury. Okay, so it could be a medical issue, it could be that they were injured and now they cannot perform their duties. They are unable to work. However, this is not their fault. Okay, so this is a no-fault dismissal. It's an unfortunate circumstance or situation. They are just unable to work due to ill health or injury. All right. The third form of dismissal or type of dismissal that we deal with is dismissal for poor performance. Okay, so when we look at poor performance, the employee is unable to perform their duties despite training, guidance, counseling, etc. All right, so what poor performance is that we've tried everything. As the employer, we've given you training, we've given you guidance, we've counseled you, we've mentored you, we've coached you, okay? We've went through the situation, we've given you examples on how to deal with certain aspects of your work. There's still no improvement. Okay, it is the fact that you are unable or incapable to perform your duties. This is a no-fault dismissal. Okay, so you're not choosing to disobey or to not follow the code or not do your work the way it should be. It is you just can't. Okay, so it is a cannot. All right, so remember, misconduct is a will not. Incapacity and poor performance is a cannot. You are incapable or unable to perform your duties or to perform your work. All right. And then the fourth type of dismissal that we had is restructuring. Now, this word may or may not seem familiar, but the word retrenchment will. So when we look at restructuring, redundancy, operational requirements, this is usually associated with the retrenchments. All right. Hope everybody is with me. If you have any questions, I will answer it at the end of the session. Okay. So before we delve into what is the differences between misconduct, incapacity, and poor performance, we need to understand where it can go wrong. All right. So the usual aspects or the usual issues we have as consultants, or we have been made aware of as consultants, is one, the poor understanding of discipline and what it means. Okay. So some employers do not know what discipline is, what it's meant to do, what is the purpose of discipline, and how to effectively action it within the workplace. Okay. The second is the poor understanding of progressive versus punitive discipline. What is the difference between these two? Okay, when do we apply progressive versus when do we apply punitive discipline in the workplace? The third one, which I personally see quite often, is poor record keeping. All right, so this is quite important because at each step you should be documenting the process. Okay, and what usually happens in this specific instance with poor record keeping is we get to the end part where we're in a hearing, disciplinary hearing, poor performance hearing, etc. And the employee suddenly has amnesia that you've never actually had the meeting, or they didn't understand what the warning was for, or they didn't understand what was discussed in that meeting that you had. Okay, so that can happen. Hence, record keeping or documentation of every step of the process is quite important to give you some type of, I want to say, proof that this discussion did happen, this warning was issued. Even if it is a verbal warning, ideally it should be documented. Okay. The third is not understanding the difference between dismissal for poor performance, incapacity, misconduct, and operational requirements. And this is quite a good one because what usually happens is sometimes employers don't understand, is it negligence? So negligence is misconduct. Is it a will not? Okay. Or is it a cannot? Which one is it? And sometimes what happens is we say, okay, it is a cannot, but we haven't fully investigated whether it was a will not, and it could very well be a will not. So that is what we need to understand first. What is the differences between these types of dismissals? All right. And it's quite important because the processes as to how we undertake these types of dismissals, or the processes that lead up to these dismissals, are quite different. Okay. So I will get to it later on, but they are quite different as to how we handle it, what steps we take, how we communicate with the employee, the correct words to use, okay, in that essence, in order to get the dismissal, or in order to get the dismissal for poor performance or misconduct, etc. Okay. The last issue, or the last problem that employers face is not following the correct procedures based on the type of issue. So like I just mentioned, is when you know it's a misconduct, there's a certain process that you have to follow. And that process is quite different when we look at poor performance or incapacity. Okay, so understanding these processes are quite important because there are differences in the way you handle these situations. So before we go into the processes, I do want to explain the progressive versus punitive discipline. Okay, remember, what is the purpose of discipline? The purpose of discipline is to correct the behavior. Okay, is to say you should not be going down path A, you should be going down path B, because that is where we want you to be. All right, it's to correct the behavior. Okay, progressive discipline is the process of increasing severe steps or measures when an employee fails to correct a problem. So that is when, let's, for example, say you have a timekeeping issue or attendance issue, right? Somebody came in late 3 times this week, or they've been coming in late for the past 2 weeks, okay? You might start off with a verbal warning. And as the problem continues, or if the problem continues, you would progress to a written warning, and then a final written warning. And then after repetitive steps, and there's no improvement whatsoever, you may end up in a disciplinary hearing. Whereas punitive discipline is inflicting the severe punishment upon someone for something that they've done instantly. So there's no progressive discipline that takes place. Okay, so minor transgression. So minor transgression is treated, or can be treated, progressively. Like I gave you the example with attendance. All right. Major transgressions are treated punitively. Okay. So when we look at major transgressions, right, and when to impose punitive sanctions, we look at things that are severe or have a severe impact on the organization. Things like theft, fraud, gross dishonesty, gross negligence. Okay, so the transgression must be major or severe enough to warrant punitive discipline. All right, otherwise we treat it progressively. Okay, whereas we start off with warnings, and then we issue warnings until we get to the point of dismissal, if there is no correction to the behavior that the person is portraying. Okay, so we're going to start off with misconduct and dismissals for misconduct. Like I explained earlier, misconduct arises from the employee's failure to abide by or adhere to standards of conduct expected of him or her. So this implies fault on part of the employee. There are 2 important aspects when we look at misconduct, okay? It is procedural fairness and substantive fairness. So procedural fairness means that the process that you followed is fair and is correct. The best, I want to say guideline, well, not guideline, the best piece of information with regards to what processes to follow, whether it's substantively fair, whether you've done everything right, is called Schedule 8 of the Labor Relations Act. Okay, it's a code of good practice for dismissal. It basically tells you what to do. For example, if there's a poor performance issue, if there's a misconduct issue, what are the steps that you should be following? So at any point, if you're ever confused, you could always contact HR Talk, or alternatively, you can open up your Schedule 8 of the code of good practice, and it shall give you a guide as to what to do next. Okay. So when we look at procedural fairness, like I said, it deals with the process when we go for dismissal for misconduct, all right? So 1, you should have disciplinary rules in place, okay, that provide a standard of conduct. So the employee must be aware that there is a rule. The employee must be aware that there is a standard of behavior. Two is where possible, corrective discipline must be applied. So progressive discipline must be applied rather than punitive. So remember, punitive is for very severe transgressions, very major transgressions, where the employment relationship has broken down irreversibly. Okay, there is no trust anymore in that relationship. That is when we go to punitive discipline. All right, an investigation must be conducted. So you cannot just take an employee into a hearing, right? You have to do your investigation. You have to get your witnesses, your evidence, your prep before you proceed to the next step. All right. The employee must be notified of an inquiry and must have reasonable time to prepare. So when we say reasonable time, that is a minimum of 48 hours that the employee must be given in order to prepare for a disciplinary hearing. So this is 48 hours, usually weekdays or work days, simply because if they would like the opportunity to consult a lawyer or any additional person, most lawyers, etc., do not work on weekends. So we try to give them 48 hours working days notice prior to the hearing so that they may prepare. Okay, so this hearing notice must have, for example, the date, the time of the hearing, the place of the hearing, and what are the alleged transgressions or the alleged charges, so they may have time to prepare for their case, for their hearing. Okay. Lastly, the employee must be allowed to respond and have the assistance of a trade union representative or a fellow employee. Okay, so they are allowed to be represented by a trade union representative or a fellow employee or colleague within the organization. They have to be given a chance to explain their side of the story. So this can happen usually in your hearing where you say what has happened and they give their side or their version of events before the chairperson makes a finding. All right, so that is the process that needs to be followed. You start off with your investigation. You first identify, is it a will not, is it a cannot, and then you move forward into whether it's progressive, whether it's punitive. Should we do a disciplinary hearing? Should we do a warning based on what has happened, and give the employee time to respond, or allow the employee to respond, even if it is for a warning. Even if you're issuing a warning, the employee must be allowed to provide explanations as to what happened. Okay, so that is procedural fairness. The next thing we look at is substantive fairness. Okay, so we asked ourselves essentially these three questions. Was a company rule, policy, or behavioral standard broken? All right. If so, was the employee aware of the transgressed rule? So were they aware that there was a policy? Were they aware that there was a behavioral standard? Were they aware there was a rule in place prior to them having broken this rule? Okay, you cannot discipline someone for something that they weren't aware of. Okay, you can't discipline them if they weren't aware of the policy, if they weren't aware of the rule. All right. And lastly, has this rule been consistently applied by the employer? Okay, so this means is in other similar cases, did you take the same course of action? All right. And remember, when we look at fairness, you have to be fair and you have to be consistent in the way you apply discipline. All right. You have to be consistent. What you do essentially for one individual in that specific case, you would do the similar thing for the next individual. All right. And lastly, remember the one thing about discipline is we try to correct the behavior. Okay. So you need to ask yourself, is dismissal an appropriate sanction for this transgression? Has the trust been broken down so irreversibly that there's nothing else we can do? All right. The next thing that you need to ensure that your company has, or as an employer or as a line manager, is that you have a company policy that provides a framework for discipline. Okay, so like I said, the employee must be aware of the rules and regulations. Right, these rules and regulations or these company policies must align with the Labor Relations Act. They must follow the fair procedure, like how we discussed just now. Progressive discipline should be applied as best as we can. Remember, punitive is only for serious transgressions. We should not be dealing with serious misconduct differently. You need to be consistent, okay? And lastly, you document every single thing that happens. So every warning should have a document with it where you have what has happened, what was the employee's response. If there's any agreed upon actions moving forward, you can also put that in the warning as well. And that should be signed up by both the employer or the manager and the employee. You have to be documenting your processes because this gives you basically your proof when you step into the hearing that you've tried everything that you possibly could. All right. So when we look at the basics of dismissals or discipline, sorry, what are the steps? Okay, progressive discipline states we start with a verbal warning, we then move to a written warning, a final written warning, a demotion as an alternative to dismissal, if applicable. Okay, so when I say if applicable, if we had someone, for example, that committed theft, right? A demotion may not be acceptable because you don't trust them at all in any part of your organization. So where possible, if we can institute a demotion, let's just say, for example, if it was negligence, maybe we could do a demotion to a less, I want to say, less effective position, or something that's not as, I want to say, what is the word that I'm looking for? Not as integral as the position that they were, where they were able to be negligent. So we would move them to somewhere where there's less risk to the business, for example. All right. So we would consider demotion as an alternative, but only to dismissal. Right. So that means when we get to the end part and we're ready to go into the hearing or dismiss, that is the only point we consider demotion. All right. Thereafter, if there's no other positions or alternate positions, we move to a hearing where we go into either a dismissal, or the chairperson would recommend a sanction for that employee. Okay, and then lastly, it is summary dismissal. So summary dismissal is used for misconduct mostly because it is dismissal with immediate effect. All right. So all your disciplinary hearings must be dealt with on the basis of your disciplinary process in line with the Labor Relations Act. So whatever your code and policy is, it should be in line with the Labor Relations Act, and that is how you should deal with your disciplinary hearings. Okay, so once again, remember, fair reason. So substantive fairness, you must have a sound reason for taking disciplinary action, and fair procedure. Okay, so you have to follow a fair procedure. Poor performance and incapacity have different requirements. Okay, so moving on to poor performance. When we look at poor performance, like I explained earlier, it is a no-fault dismissal. So this means that the employee is unable to perform. So this is also used in cases of probationary periods, where you are trying to assess whether the person can successfully work in that position. All right. So here what we do is we look at what are the standards of performance that we're looking for. What are the KPIs? What is in your job description? What is your targets or your goals if you're in sales, for example? All right. So we have to make an objective assessment. Okay. Number 2 is we need to provide appropriate training, instruction, guidance, and counseling. Remember, we have to show that we've done everything possible to assist you. Okay, as the employer or the manager, we need to do our best to help you in the situation, because remember, it's a no-fault dismissal. We're not saying it's your fault. You cannot. It's a cannot type of situation. All right. 3 is we need to provide you with reasonable time to improve. So a question I get a lot is, what exactly is reasonable time? Is 2 months reasonable? Is 1 week reasonable? My advice is you look at what the job is. So look at what is required of that employee, and then determine the reasonable time frame. So for example, if you have a tea lady, okay, her only job is to make tea and, sort out lunches and things like that. The reasonable time frame for me would be approximately 2 weeks, because in 2 weeks, you're going to see whether she makes good enough tea or not. All right. The other thing, or the other end of the spectrum, you might have an operations manager. Okay, so operations manager who is failing to perform, they are in charge of a lot of things, a lot of decision-making items. They are in charge of the operations of, maybe it's a warehousing, whatever the case may be. 2 weeks may not be sufficient for them. So they may need a month, they may need 3 months. Okay, so it depends on the type of job that the person does, but it needs to be a reasonable, justifiable time to improve. Okay, so 4th is we do an investigation for the reason of poor performance. We need to understand why you're performing, because we've given you the training, we've given you the instruction, we've given you the guidance, we've given you time to improve, but you're still not performing. All right. Then we move on. Can we do a job transfer? Is there any alternate positions for you? Because remember, it's not your fault. It's a no-fault dismissal. It's a cannot, right? So is there any other positions that we can put you in? And lastly, throughout this entire process, remember, trade union rep or a fellow employee may represent or assist in this process, okay? So if there's no job transfer, what we usually move to is a poor performance hearing. All right. So just remember, in every meeting, so you would usually have counseling sessions. In the case of poor performance, you would not do warnings, because remember, warning implies you did something wrong. That's why I'm giving you a written warning. I'm giving you a verbal warning. In poor performance, we do counseling sessions, right? So your counseling sessions is basically where we talk about what are my requirements, what are the standards that I require, how are you performing, why do I think you're not performing, and how do we move forward? What is the time frame for improvement? I will be monitoring you, things like that. All right, that's what you discuss in your counseling sessions. All right, after the hearing, so let's just say we've done all of that. Now we've gone to the hearing point, right? So we hear the employee, what is the employee's reasons for their poor performance? We develop and initiate counseling and instruction. All right, so we've done all of that. We've assessed the employee, the time that it's taken to improve. We've monitored them on the basis of the assessment. We've established realistic timeframes, all right, reasonable timeframes. We've identified and provided appropriate training. We've established ways to address any factors that affect the employee's performance. So we've done everything that we can, but it's still not fixing itself. The poor performance is still there. We then move into a poor performance hearing. All right, very similar. That can include, maybe before we go there, we'll look at alternate positions, like I said, and then we need to ensure that we've done everything we can before we consider dismissing the employee. Okay, moving on to incapacity. Like explained earlier, incapacity is the inability to perform part of his or her duties on the account of ill health or injury. Once again, it's a no-fault dismissal, right? It's not the employee's fault that they cannot perform. It's due to ill health or injury. It's a cannot type of situation. When we look at incapacity, there's certain things that we look at, right? So we start off by, is there a pattern of sick leave, right? Or lengthy absences from work, okay? Has the extent of the employee's ill health or injury been investigated? So we need to investigate. That may include sending them to the doctor with a job spec to say, are they capable of performing their duties, all right? And then what happens if they're not? Okay, so if they're not capable of performing their duties, you've sent them off to the doctor, they come back and the doctor says, okay, you either need to make modifications, because that's what is the best scenario, the best outcome for this. Now, can we as the employer or as the manager make modifications or adaptations to this person's environment or to this person's role in the organization? Okay, has the availability of a suitable alternative being considered? Okay, so let's just say we can't make adaptations or we can't make modifications. Can we move them somewhere else? Okay, can we put them in a different positions? Do we have positions available? All right, so in the cases of substance abuse, so for example alcoholism and things like that, is counseling or rehabilitation an appropriate course of action at this point in time? We need to consider these factors when dealing with incapacity. Okay, so just remember, in terms of the Employment Equity Act, it is not considered unfair discrimination to, one, distinguish or exclude a person or prefer any person on the basis of the inherent requirement of the job, or testing of the employee for any medical reason is prohibited unless it is justifiable in light of medical facts, employment conditions, or the inherent requirements of the job. So remember, incapacity, they are not performing. If they are unable to perform their duties, they are unable to work because of ill health or because of injury, right? So it is not unfair discrimination when we look at the Employment Equity Act. So in terms of the LRA requirements for incapacity, so the Labor Relations Act, what we look at is, if the employee is temporarily unable to work, can we, or firstly, we should be investigating the extent of the ill health or injury. So how far along is it? Is it so bad where maybe we need to consider medically boarding the individual, or what is currently happening, right? If the employee is likely to be off work for an unreasonably long period of time, the employer should investigate all possible alternatives short of dismissal. So remember, we have to try everything we can, because the whole point of discipline is not to terminate individuals, it's to create a cohesive, positive, harmonious working environment. Okay, the employer should consider whether the employee can perform the work required, and if the employee cannot, then to what extent, what can they do? What can't they do? Okay. Can we modify? Can we adapt? All right. Can we provide a suitable alternate working environment, or can we provide an alternative role for this employee? Okay. We need to consider all of these things. And then the cause of incapacity is relevant should the employer decide to dismiss the employee. So we need to identify what was the cause of incapacity. Is it ill health? Is it alcoholism? Is it drug abuse? What exactly has happened? All right. So remember, you would start off by noticing the sick leave patterns. Okay. If there's sick leave or lengthy absences, you would then proceed to have discussions with this employee to say, is there something that is concerning? You know, we've noticed this. Are you okay? Okay, it is not stating that they've done something wrong, because remember, this is a no fault type of dismissal or discipline. Okay, so what exactly is going on? Then we say, okay, we may need to send you to the doctor to see if you're capable of performing, because it is now affecting your work. All right, and then from there we wait for the doctor's recommendations, and we take it one step at a time. Okay, I do know I threw a whole bunch of information at you guys. If you have any questions, please feel free to pop it in the chat. If we do not have time now, I'm happy to revert via email. And should you wish to purchase the assessment for this training, you can find it on our online shop on our website. But just to end off, in summary, what is the differences between misconduct, poor performance, and incapacity? Remember, misconduct is a will not, okay? You are choosing to disobey or not to follow a code of behavior that you are already aware of. We look at progressive discipline. We look at trying to correct the behavior. Punitive discipline is only used in severe cases, like I explained, theft, fraud, gross dishonesty, things where the trust has broken down completely. There is fault on the employee, and this is where we consider summary dismissal. So summary dismissal is dismissal with immediate effect. Okay, the other two, poor performance and incapacity, these are no fault dismissals. All right, these are no fault dismissals. It's not the fault of the employee. They are just unable or incapable to perform their duties. Right, when we look at poor performance, we look at training, we look at guidance, we look at counseling sessions. Okay, we look at ensuring that they understand the requirements of the job. All right, and if a job transfer or alternative position can be considered, because why? It's a no fault dismissal. All right. The other one is incapacity. Like I said, it is a no fault dismissal. It is due to ill health or injury. Okay. So we look at, can we modify the position or the work environment in order to keep this employee? Okay. Can we find them an alternative position before we consider dismissing the employee? All right, that is the inherent differences between these three. Remember, the processes are different. Misconduct, we give warnings, we discipline. All right, poor performance and incapacity, there's counseling sessions involved. Incapacity, you would contact a doctor, maybe do a medical testing to ensure that they are capable for their job, things like that. Poor performance, we provide training, counseling session, guidance. These are the differences. We would not discipline, so we would not give warnings, whether it's a verbal, a written, a final written warning for poor performance and incapacity, because remember, those are no fault dismissals. Okay. I'm almost to the end. This is my last slide for today. So this is just an example of where it could go wrong, or where it has gone wrong. All right. So Danelle has failed to perform her duties, which has resulted in a loss to the company. Okay. So what has happened? We said loss to the company. For example, Danelle lost the company 500 or 200,000 rands. Okay. Gross negligence because of the severity. And then we move straight into dismissal because it's a severe transgression, because we've lost 500,000 rand to the company. All right. Then it goes to the appeal stage or the CCMA, and the commissioner says, no, it's actually not discipline misconduct. It is actually poor performance. And what has happened is we have now failed to follow the process. We didn't have counseling sessions. We didn't do an objective assessment. We didn't provide training, instruction, and guidance. We didn't give them reasonable time to improve. So now we actually did not follow the correct process in terms of the CCMA processes, in terms of the Labor Relations Act. So this becomes a problem. So the first point when you notice something going wrong. The best piece of advice I can give you today, the only thing you should be taking away, if you take away one thing today, is you need to identify, is it a will not or cannot from the get-go, okay? From the onset of the behavior or of the absenteeism or whatever it is, you need to identify, is it a will not or is it a cannot? All right. And then from there, you know which part to take, because identifying that part makes the process either, remember, procedural fairness and substantive fairness, fair reason and fair process. Okay. We need to ensure that we are abiding by all of this in terms of the Labor Relations Act. Okay. So I have come to the end of my presentation. I do know there was a lot of information. I'm not sure if there are any questions in the chat. Yes, there are. Okay. Okay, let me just get there. Give me a second. My question and answers are currently loading. Just give me one more minute. Okay, so one of the questions is, what happens if the alternative role available has a lower salary than what the employee is currently on? Remember, when we look at alternative roles, it is an alternative role short of dismissal. Okay, so the employee has a right to decline the alternative role 100%. Okay, but remember, what happens if they do? We're probably going to end up in a dismissal situation where they're not going to have a salary at all. Okay, so they do have the opportunity to decline the alternative role, even if it has a lower salary. But what we need to try and do is ensure that we have given them that opportunity of the alternative role. All right. I don't see any other questions. I only saw that one. I assume everybody is good. Like I said, if you guys want to do the assessment, we do have an assessment available from this webinar. It is on our online shop. On our website, you can go in and purchase the assessment, and what would happen is you would get a certificate at the end to say that you completed this assessment or this course. All right, and you can probably use that for your skills development mandatory grant submission. Okay, thank you so much everybody for joining me. I hope that it was informative, and I hope that everybody learned something today or brushed off or refreshed their memory on certain aspects of discipline, and have a lovely day ahead.